One frequently asked question that we get from people who have DUI charges is, how can I avoid a DUI on my record? And the truth is, it's not easy to keep a DUI off of your record if you've been charged. The most effective method for me and my clients in the past has been getting this charge amended or reduced to a lesser offense, such as reckless driving. Reckless driving doesn't come with the same penalties as a DUI, and it will not have the same effect on your record. And of course, that begs the question, how can I get my charge amended from DUI down to reckless driving? Here are 3 tips that have worked for my clients in the past. Number 1, if you can demonstrate sobriety and you can maintain that and prove that to a prosecutor and a judge, it's often very helpful in persuading them that you do not have a severe alcohol problem that would necessitate you being found guilty of DUI. Another method is community service. If you're giving back to your community as a volunteer and showing the prosecutor and the court that you're aware that you made a mistake and you're trying to do everything you can to make that right, frequently it will persuade a judge, for example, that you don't need 48 hours in jail because you did 48 hours of community service. There's no guarantee, of course, that a judge will give you equal credit, but it certainly is helpful in persuading them that you deserve to have the charge reduced. A third method that's very effective is character reference letters. People in the community who know you and have good things to say about you as a citizen can write letters to the court. We can have those sworn and notarized. We can present those to a prosecutor or a judge before they decide how to handle your case. The second method that has worked for my clients in the past when they want to avoid having a DUI on their record is to wait. Too many lawyers show up in court, they can't get the results that the client wants, and so they just plead guilty. But one strategy that's been effective for my clients has been to not plead guilty and to tell the prosecutor that we want to develop more evidence and come back with a stronger case showing a more lengthy period of demonstrated sobriety. We want to do more community service, anything that will buy us more time. And in the past, I've actually had cases that were dismissed because they went on for long enough that something happened to the police officer who could not be present for trial. Of course, that's very rare, but waiting is definitely one of the strategies that works. Of course, the third and best way to avoid having a DUI charge on your record is to have the charges dismissed. Now, that is rare, but in the past, I have had cases where my clients' DUI charges were dismissed. The easiest way is if the charges are dismissed pursuant to a prosecutor's motion to null pros the charges, which means that they're choosing not to go forward with their case for whatever reason makes sense to them. The much more difficult way is an acquittal. That means that your case was tried in front of a judge or jury who were not able to find you guilty as charged and instead acquitted you of the crime. Of course, that's the best outcome in a sense, but it's much easier to get the charge dismissed before you are placed on trial. That way, you don't have to roll the dice and take a chance that a judge or jury will not acquit you. I hope this information's been helpful. If you have any questions, feel free to call us at 1-866-VAN-WINS.